Okay, your grades are now on Moodle, so you will have seen there. You guys did really, really well. I'm very, very pleased. The grades range from 14 to 19 out of 20, but most of them were at the upper end of that scale. So a lot of you put some thought into it. I certainly appreciated that. A fair number of you actually told me that you were, basically, emotionally involved or engaged in the video itself, and you appreciated seeing that. So I'm glad you did in fact appreciate it. So we'll talk about that when we get to the discussion part of the class. All right. Next things on the agenda is your final paper and or final exam. So it's time to give some thought to that. As you know from the course outline, I've given you the option of either doing a final exam or a final paper. So the final exam will be along the lines of your midterm. It'll probably be in the order of about 120 questions, which will be true or false or multiple choice. So pretty much the same format as the midterm. So you guys have a pretty good idea what that is. So you can take it from there. You also have the option as an alternative to doing the exam to doing a final paper. And so I've posted the topic for the final paper on Moodle together with what's required in doing it, which is essentially an 8-page paper, essay style. It has to be properly cited, all the kind of things that you would expect to do in a third or fourth year class at Algoma. All right, so I've given you a topic on Moodle that you can certainly use, or in the alternative, you can suggest to me your own topic if that's something that you want to do. In either case, I need you to tell me by a week from this Friday, so the 26th of March, and I will send you a Google form for this purpose. I need you to tell me whether you would like to do the final exam, which is perfectly fine, or the final paper. And if it's the final paper, whether it's going to be the topic that I have suggested and posted on Moodle for you, or your own topic. And obviously, if it's your own topic, I have to approve that for the purposes of your paper. Okay, any questions about that? It's pretty straightforward. Okay. All right, let's move on to the discussion. So the discussion tonight is on the film that was the subject of your film study, which is We Will Stand Up. So does anyone have anything they want to say about the film? And again, you can certainly repeat what you've told me in your film study because your comments were really, really good. Larissa.
Um, I think the biggest thing for me was the emotions to it didn't really impact me until I sat there afterwards and I started playing it all back in my head and thinking just about like the RCMP is super racist, especially from the views of the film. Like you see how that whole case was mishandled and the whole thing was just an atrocity that happened and it's really appalling. And it just because like the victim's family got treated like a bunch of criminals and it just broke my heart to know that that's like a normal everyday occurrence for these people.
Yeah, yeah, absolutely, absolutely true. And again, remember that the RCMP, who tend to be more often than not Caucasian, right? And in the prairies, they sympathize to a great degree with the residents who complain about thefts and trespassing and what have you. So yeah, it was really meaningful. Elizabeth.
Yeah, I agree completely that I think, you hear about these racist things going on and you don't really realize the impact of actual people. Like you understand the impact of like the system and the group, but not individually. Like I think the viewpoint of like coming at the documentary from like the family's perspective opposed to like just like generally the case of what happened was a good thing, because I think it shows like putting people's faces and people's stories to these racist things, I think actually helps like humanize the issues. I think, yeah, it was like it was quite emotional to watch, I think, because I remember learning about this case in another one of your classes, but I don't think I realized like how big of an impact it had on people, but then also just how big of a mess up that was on the RCMP and just even on the criminal justice system as a whole.
Yeah, one of the things regarding the RCMP, they didn't make a big point of this in the video or the film. They should have, was that the vehicle, obviously where Colton Boushie was killed, the RCMP left it out in the open, right, for days and days on end, which basically eliminated the prospect for any forensic examination of blood spatter, and which obviously would have been really, really important in this case, regarding the fact that Stanley, shot a gun off, at the, behind his head, kind of thing. But I mean, that kind of thing is just unbelievably negligent from a policing point of view. And they did it and didn't think twice about it. So the film didn't emphasize that, but it was a very real factor. And certainly one of the factors that led away from a conviction for Stanley, simply because the forensics didn't support the conviction. So thank you. Jerry.
Yes, hi, hello, thanks. Yeah, I just wanted to, I agree with everybody what's been said. And I just wanted to point out with Boushie being killed, like the farmer, I don't agree with them going onto his property, but I also don't agree with him having been shot and killed over a piece of farm equipment. Like he had a choice; he could have maybe did something else instead of resorting to that. Like the mom said, he could have shot in the air or shot somewhere else, or I don't know.
No, that's a really good point, and we have to keep that in mind too. We have to keep in mind, that he was on the property with his friends. Now he may have fallen asleep in the car, in the backseat of the car, and then he moved to the front seat of the car. But he was on the property trespassing, and the film again didn't say a lot about this, but it's really important because you have to have context, because you really have to think, why would the jury acquit this man who clearly was at least criminally negligent in having a gun in his right hand while he was ostensibly reaching in with his left hand to turn the ignition key off. And there's a serious problem in the prairies, Saskatchewan particularly, with young Indigenous people going on other people's properties, breaking into vehicles and stealing things, and it's relatively minor stuff. It really is. There's nothing. There's no indictable offenses taking place when they do that kind of thing, but you have to, and this is where the jury went to. Obviously, you have to think of Gerald Stanley in his mindset, with people being on his property, breaking into his, they went to jump on one of his quads, kind of thing. You have to keep that in mind. So there are two sides of it, although taking a life is never excusable. And it was made pretty clear in the video that what he should have done, clearly is, shoot, if he's going to have a gun at all, shoot it in the air to scare the people off. And the two guys in the vehicle that were with Boushie ran off anyway, right? And only reason he didn't, run off is because, first off, he was asleep when Stanley came out, and then, he was there with the two women that were in the car as well. And whether he was protecting them or he was just moving around, we really don't know. But you have to keep that context in mind. But again, certainly, the emphasis in the film was that, God, why would you, put a gun beside somebody's head for this kind of thing? It's totally inexcusable. All right, so let's talk, Abigail.
Yeah, just kind of going off of what you just said, the part that I found to be really interesting, I mean, obviously there's a lot of racism within the RCMP and the criminal justice system, but I find to an extent now, like, I'm kind of desensitized to that in a way. Like, you hear about it a lot in the news and whatnot, and not usually cases quite to this extent, but you hear of similar sorts of things that go on, which is horrible, obviously. But when they were showing that town hall scene and kind of all the farmers and kind of the same class of people like Gerald Stanley were talking, and they all shared his viewpoint, and they were all very like aggressive about it, I found that part to be really shocking, because you think of it kind of in a way, there's the government and the criminal justice system over in one corner, and then you have the citizens who feel that this is wrong in another corner, but that's not what that reflected.
Right. Yeah, exactly. Rainbow.
Okay, so I guess I kind of just wanted to say that in regards to like the whole thing about the RCMP, like that, I just had like a conversation at like my work where like a big part or big like initiative of the RCMP right now is like having that sort of like Indigenous representation. So I think like things like that is like super important, especially going forward. And like when you like consider like the differences, I guess like from province to province, especially with like Indigenous communities, like I think a big part of like that film or like the film highlighted was the culture or like that farmers culture in Saskatchewan, and that I think contributed a lot to like what or how like the trial played out. So yeah, I think that's all I wanted to say.
No, that's good. And again, remember, this really was a conflict between two cultures. You know, the white culture, the ownership of property culture, you know, don't come onto my property kind of thing. Although, and there was a point in the chat about this, and it's absolutely true. You know, we don't have a stand your ground uh, regime in Canada, whereas many of the states in the U.S. have a stand your ground regime, which basically means if anybody comes on your property, you have the right to shoot them, right? And that's seen automatically as self-defense. We don't do that in Canada. That's not the kind of position we take, right? But you do certainly have that culture of property ownership, which means ownership to the exclusion of everybody else. And again, and some didn't show this, but it's required to understand the jury is that you know there is a very much a problem with young Indigenous people, you know, going on private property and doing damage, right? And we can't escape that. So you know, we can't, you know, to put this in context, you know, as tragic as Colt Boushie was, you can't, you know, take away the fact that he was on somebody else's property, right? You know, clearly the extent that Gerald Stanley went to protect this property is indefensible. It really is. But having said that, you have to realize that the defense, you know, the defense counsel for Gerald Stanley at the trial, that is the picture they would have been painting during the entire trial. That this is a young man who had no right to be in this property. You know, property is being broken into, and farmers are being robbed all the time, and it is endemic in the prairies, right? And clearly, and we'll talk about this when we do criminal justice a little bit more in a couple of weeks. We'll talk about the Boushie trial because of the selection of the jury, which was all white, essentially. But clearly, that's what the defense would play to, and that's their job to play to that, right? If you're a defense counsel, it doesn't matter whether it's you're accused as Indigenous or white or whatever it is. Your job is to absolutely defend your client to your best of your ability, and that would have been the picture that would have been painted. Is that you know this person, you know, was improperly and illegally on somebody's property, and you know, but you know, but in real terms, that wasn't actually what the defense ended up being. Um, Anybody want to tell you know anyone want to say what the defense actually was? The one that actually carried the day. It wasn't that he was protecting his property and he had the right to do that, and he accidentally killed this young man. That wasn't the defense. What was the defense? Anybody?
The defense was the hang fire defense, right? Where
Exactly.
he claimed that he had shot or pulled the trigger at a different time than when it was aimed at his head. So he wasn't actually aiming at his head when that happened, which I don't know. I kind of think that's a bit ridiculous because I think that if you look at the witnesses and the experts on ballistics on both sides, it was very clear that it wasn't possible. But anyways, I digress.
No, Elizabeth, you're absolutely right. That was the defense. The defense wasn't protection of property. The defense wasn't, that Colton Boushie was a threat of any kind. The defense was that it was totally an accident. That Gerald Stanley pulled the trigger to his gun. It didn't go off, and then he just happened to have it in his right hand. You know, a very short period thereafter, when he was reaching into the vehicle to get the keys out of the ignition, and it accidentally went off. The hang fire defense, which from a ballistics point of view is incredibly narrow defense. Both the ballistics and the people called by the defense who weren't ballistics experts at all have all indicated that it's a possible. It's a possible kind of thing to happen, but very, very rare. But again, keeping in mind the culture of that white jury, listening to the defense arguments, they were more than happy, obviously, to hang an acquittal on that defense. That gave them enough of a reasonable doubt to acquit, which was pretty amazing because this, without a doubt, this should have been a manslaughter. At the very least, a manslaughter. So even though he was charged with second-degree murder, manslaughter is a lesser and included offense, and why the jury didn't go there is a mystery to me. But you don't get to in our system hear what the jury deliberations were. That's a totally improper approach. Okay, Jacob.
Just to go off the point that Liz made about the hang fire, I think that they also tried to do that. He was in such a tricky situation or position with his hand into the key, trying to get the key out of the ignition, and his gun above his head. They tried to make the claim that he accidentally fired it because he was stretching his body weirdly.
Yeah.
So I just want to make that point.
Yeah, exactly. Although there was some evidence in the film about how it would almost impossible to to have your hand with the gun behind his head and then still be able to reach through the steering mechanism to get to the ignition. There was some evidence in the video that was almost impossible to do. But having said that, clearly the jury was of a different opinion. Balpinder.
Hi. The point which I think after watching the video is like, I feel that like in the past, as they were talking about Treaty 6, like the treatment they get from the legal system is like same they're getting still today. And inspired, like we're talking about like truth reconciliation programs and everything, but like in actual, like they're not still treated in a fair way they're supposed to be. I mean, the discrimination is not like only in the society they're getting, but it's also from like a legal side. So there's no point of doing like reconciliation if like this kind of system is like still going on like in like legally. That's what the point I want to make for this video.
No, thank you,
Thank
Beth.
you.
No, that's good. I mean, that's absolutely true. Is that we're still a long way away from removing things like systemic racism from the criminal justice system. We're a long way away, and we'll talk about that in a couple of weeks. But there, the one thing that has come out of this Colt and Bushi matter has been an amendment to the criminal code to remove the availability of what are called prerogative challenges to jury selection. And again, we'll talk about that in a couple of weeks. But it cost the young man his life, but it did close a loophole in. Some people see it as closing a loophole in the jury system or the jury selection system. Let's see. We have Carolina.
Yes, I just wanted to say that the part that resonated with me the most was the speech and the journey for justice of the family during the forum and taking the stand. And it's because it showed how the legal system in Canada has failed them from the beginning and that they have to reach out on the international level for support to be heard about their rights. I felt that was very strong, resonating with me. And I also think that the whole case not having inclusion of any of the Aboriginal judges, it just really supported the individualistic culture, and there was no repercussion of doing harm to the society and the community, which is exactly the problem. Because of the two cultures, they just don't mix together. So I think that the roots of it all come from even not being able to be on your own land, right? And just that whole segregation. So I think that this whole case is just an example of the legal system failing and an example of the colonization that continues.
Very good. I appreciate that. Lots and lots of stuff in the chat box, so certainly take a look at it if you guys get a chance. Does anybody else? I see Ursula and Emily still have their hands up, but I presume that's from previously, unless you have something more to add. Ava, your hand's up.
Yeah, I don't know. I just I was watching it, and I actually watched it with my parents, and tried to get some other opinions as well while I was watching this. And, it was kind of interesting looking at it from a different kind of perspective. And they basically were saying, as like my dad, for example, who grew up on a farm, something like someone breaking onto your farm automatically is sort of like, I don't know, like a big violation of trespassing, because they work so hard every day up so early in the morning to take care of their animals, cattle or whatever, and the tractors, all sorts of stuff. It's all super expensive equipment, and these farmers work day in day out to be able to make this living for themselves. And so it's almost this more capitalist sort of I guess mentality, where this is my property, kind of stay off my property, I put all my work and seed into this energy, blah blah blah. And I guess a lot of people think of it like, oh, in the city, if someone were to real quick come to my place and try and break in, you can call the cops real quick, and that happens a lot of times in these other communities where things are spaced out. The time that it would take for police or RCMP to even get there, he could have been killed, shot, or he could have had his ATV stolen, all sorts of things. And so I really think that people need to put into the perspective that we living in where we do, we're very privileged and such. And, just because this guy was white, he still wouldn't have, the same kind of education, most likely growing up, being told about this stuff. So he probably was just acting completely in self-defense. And again, I know I'm not making excuses for what he did, because it's awful, it's terrible, but I really feel like there's a different mindset and a much more, I need to stand my ground to protect my property kind of mindset. And if people take that into account, it's a lot different from like how we would have reacted,
Well, no, it's true, and I was trying to say that earlier, because again, you have to remember that we have two cultures here, and the one culture that is that it's Western civilizations, and you're right, it's a capitalist philosophy that you own property, it's your property, you bought, you paid for it, you're probably still paying for it, you have expensive equipment on it. And you have fences, that everybody has fences, put up for the purposes of saying these are the boundaries of my land, right? And so there's absolutely, and it's a defensible culture to believe that it is your land, and those people who come onto your land who aren't supposed to be there, i.e., trespassers who are there illegally, should not be there and should be told to get off the land. The clash of the cultures, obviously here, is that you don't necessarily have to kill somebody to get them off your land, right? And that's where the charge of manslaughter should have certainly stood its ground in Gerald Stanley's case. I mean, that's absolutely you can't unless you're being attacked in some way, or you believe that the only way to defend your property and those around you is to use violence of this nature, then you don't have a defense. And so you have to realize that you do have that. The everybody who is upset about Colton Boushie being shot has to face that other part of the spectrum, right? And obviously that's what the jury bought into, right? And so that's where it's all involved. Okay, so I still have Ursula, Emily, and Elizabeth. You guys still have your hands up again, or is it from before?
Yeah.
Sorry, Emily?
All right. Yes, I wanted to say something.
Sure.
First, I wanted to say about the film that I'm really happy that the main, oh my goodness, what was her name? Tasha? I can't remember her name, but the one who made the film, I'm happy that she got the chance to reconnect with her birth father. And because a lot of times Indigenous children who get put into white households don't get that opportunity to reconnect to their roots. And then also I just wanted to respond to Ava's comment. I think she's kind of overgeneralizing what this film was about, because the point of this film wasn't the fact that we should look at both sides. It was the point of this film being made was the fact that if Colton was white, he wouldn't have been left out in the rain. If Colton was white,
the truck haven't been left out and not swept for evidence right away. And if Colton was white, Gerald probably wouldn't have been appeased of the crime. And yeah, that's all I wanted to say.
And those are good points. I mean, because of the racist nature of criminal investigations, particularly in the prairies, you're absolutely right. I'm sure that's true. That if a young white man had been killed on the property, it would have garnered the attention of a lot more than just Colton's family and their supporters. So it's a good point. Ursula?
Yeah, I just wanted to also make that same comment. I was actually thinking that. I was just saying, like, I wonder if the same result would have happened if it was switched. Like, if he was a white man, I mean, like, there were white people in the vehicle, and I don't understand where it's self-defense, because obviously they didn't have any weapons. Like, he's seen them trying to be pulling out of his property, but they were like, it sounded like they're terrified because they've seen them, right, coming running at them. I don't know, like, I just can't help but saying that too. Like, I wonder if this would be played a lot different if they were non-Indigenous.
Oh, sure it would have been. Absolutely. Ava, do you want to respond?
Yeah, I feel like with everyone here kind of having the same idea, I guess I wanted to give a little bit of a difference of opinion. But obviously, I'm aware that if he were white, there'd probably be a higher chance of him being alive, considering, when people see, I guess, what they recognize, they're more comfortable. I suppose that's just the world that we live in, and it's unfortunate. I don't think 100%. If he was white, if he was still breaking in on the property, I still think there's a chance that he would have been shot. Again, that's just the culture of that whole protecting your land kind of thing. Do I think there would have been maybe different retribution if he was white? Yeah, that's a huge possibility as well. But again, I know all this stuff. I know everyone's saying all the same thing. I just wanted to give a little bit of a different perspective. I wasn't trying to insult anyone. So
no, this is near university. I mean, this is what we're here for, is this kind of dialogue. So that there's absolutely nothing that you guys can say to each other that isn't appropriate within the context of this discussion, because the sides are pretty, the sides are clear, the positions are clear. There's a culture clash. Obviously in the case between Stanley and Bushy, so it's really important that we get these things out front. Michelle.
I think I agree with Hammurabi's code. I think an eye for an eye, and I don't think that, how much is a four-wheeler? $2,500, and I think a human life is worth way more than that. And I don't care what color your skin is. I don't care who you are. I don't really care what you're doing. Really, honestly, I think that, what the consequences of his actions and his friend's actions that day superseded the crime itself, is what I think. I think it was, I don't care what he was doing. I think someone died, and I think that whole issue has been put under the rug. And, like I was saying in my essay, that Chief, what is Belgrade, Perry Belgrade, he's the leader of the First Nations, Assembly First Nations.
Yep.
And that's, everybody lost sight of what happened that day. Somebody died. It isn't the fact that somebody was on somebody's land. You know what? Somebody comes onto my land all the time. I'm not going to kill them. Whatever. I'm going to try to help them if I can, whether they're trying to steal from me or not. Material things aren't worth someone's life. I just, that was my opinion on that, sir.
No, thanks, Shaw. I appreciate that. Does anybody, I don't know if the hands are still up or not up. Anybody have anything else to say before we close the discussion?
Can I say something? Sorry.
Sure, Eva, sure, go ahead.
Again, different perspective. As someone who lives in a really sketchy neighborhood and had some crackhead try to break into my place the other day, that is the most terrifying thing. And if I had a gun, I would have shot him. So I know people can say, oh, well, I would do nothing and I'd let them rob me all you want. But there's literally nothing more terrifying than having someone come onto your property and literally try and steal from you. I had someone with a flashlight looking through my window as they robbed my place outside. And if, like I said, if I had a gun, I would have shot them. So I really, if everyone can say they do this or that in certain situations, But until you're actually put in that situation and you fear for your life or your property, whatever it is, you really don't know what you would do. And if I had a weapon and someone was trying to rob me, 3 guys even were on my property and I'm an older man, yeah, I'd probably want to shoot them. Like, I don't think that what he did was necessarily right, but I feel like under the circumstance and given I've been through a similar circumstance, I feel like I would have done the same thing. Not shoot him in the head, but I probably would have shot. So I can't, it's sad, it's tragic, but they shouldn't have been on his property. And that's why we have those trespassing rules. So people don't think that they're in danger. And he clearly felt as if he were in danger.
Well, the one thing, thanks, Eva. The one thing, I'm just going to end it here because we have to get to the lecture. It's been more than half an hour now, which is, I really appreciate. The one thing we have to remember is that, the vast media response to this has been, of such a nature that, I guarantee you that, notwithstanding the culture clash between white farmers and Indigenous young people coming onto the properties, that everybody will think twice about what they do going forward, right? Because nobody, in this country has not heard of this case, right? So there's a lesson to be learned. So that's a really good thing, all right? And we're going to talk about some more when we're going to talk about Colton Bushy and what it beneficially did for the criminal justice system with respect to the selection of juries when we get there in a couple of weeks. All right, guys. So I'm going to stop us there for that. There's more things in the chat for you to look at, and that's absolutely fine. So we're going to move on now, and we're going to deal with the lecture. All right, so what we're dealing with now, basically, so this week and next week, we're dealing with land issues, which deals with treaties, all right? And, the vast majority of cases that are litigated and make their way to the Supreme Court of Canada, and we'll touch on some of these cases tonight, are ones that deal with, either land rights or treaty rights, all right? And treaty rights often are litigated with respect to the Ontario government or the federal government, basically bringing charges against an Indigenous person for breaching whatever laws are in place. And the Indigenous, the Indigenous respondents come back and say that they didn't break the law because they were just simply exercising Indigenous treaty rights. Sorry, guys, hang on. Okay, so that's going to be this. So tonight we're going to start with land issues and treaties, and we're going to do a bit on what's called the specific treaty tribunal process, which is where Indigenous peoples can take treaties before a tribunal, basically alleging that there's been a violation of the treaty. So that's tonight, and then next the class will continue with Indigenous law, and we'll deal with what's called comprehensive land claims, which are both violations of what are called modern treaties and the establishment of modern treaties, which is what we're doing right now in those parts of Canada where in fact treaties don't yet exist. And there are still parts of Canada where that happens. Okay, so that's this week and next week. All right, so first things first, all right, and this is a bit of a background. You guys already know this. So the British North America Act of 1867 gave the federal government jurisdiction over Indian lands. Actually, Section 9124 of the BNA Act of 1867 to become the Constitution Act of 1867 says that the federal government has exclusive authority over Indians and lands reserved for Indians. All right, and that is an incredibly important provision. We talked a lot about that when we dealt with the Daniels decision at the beginning of the semester. All right, in 1876, the Indian Act was put in place. Again, this is by the Macdonald government. So John A. Macdonald, who was the first prime minister in 1867, he remained prime minister for about 20 years, and he did a lot of damage to Indigenous Canadians during that period of time. But the Indian Act was essentially an amalgamation of all the legislation that the pre-Confederation, the British government had passed, and post-Confederation, the 9 years between 1867 and 76, that the Canadian government had put in place with respect to Indigenous Canadians. The Indian Act, without a doubt, is a paternalistic piece of legislation that, to a great degree, removed all governance ability for Indigenous Canadians to look after themselves. They became essentially wards of the state, clearly under the control of the federal government. Most First Nation communities became economically dependent upon the federal government because, as a function of entering into treaties, they lost the vast majority of their lands. They were put onto reserves, right? And that's where they had to rebuild their lives, which meant they lost the economic base to some degree of hunting and fishing. And certainly if they had any base for trapping and or farming, it was gone when they were relocated and concentrated into reserves. This is a brief video. It's as long as the sun shines, which is a really important phrase when it comes to treaty rights. So we'll watch this and then move on.
We are here to talk about a matter that is close to our hearts as First Nations people and central to our identity as the first peoples of this land. Our treaties, the lifeblood of our nations. Prior to contact, Europeans and our people were in separate worlds. In one world, distinct nations were making laws, selecting leaders, educating their children, developing their economies, lands, and resources, and entering into military alliances and trading pacts. Meanwhile, in Europe, much the same was happening. Each world was home to many nations, each with its own laws, languages, cultures, citizens, social and political systems. The first peoples of this land, the Cree, the Anishinaabe, the Haudenosaunee, the Dene, and all the others were in our nations. It is the nations of these two worlds that entered into treaty with one another. By that very fact, treaty making, it is clear that the Crown viewed our people as part of nations. For only nations enter into treaties. And now today, Canada is gathered with us once again to talk about these agreements. Spirit and intent. This is the context of our work over the next couple of days here. Our goal, in the most basic sense, is to talk about how we give life to the original spirit and intent of our treaties. Today, in the modern sense, in 2008. I know some would say that this work is easy because we don't need to be concerned about the spirit and intent of the treaties. They argue that the treaties say what they say. And if the treaties speak only about, for example, cows and plows, then cows and plows it is. This is clearly not the case. First Nations negotiated treaties in good faith and signed them or affixed their clan symbols based on their understanding of the results of these discussions. There are many examples we can point to. When the Anishinaabe negotiated Treaty 3 at Northwest Angle in 1873, they hired their own interpreters to keep a record of the deliberations. This record, now known as the Pepom document, clearly shows that there are significant number of differences between what was agreed to and what was signed. First Nations, our people should not be penalized for operating on good faith. Our people often consecrated these historic and sacred treaties with a pipe ceremony or a prayer. They're not simply contracts to us. They're not merely a real estate transaction. They're sacred agreements. They're intended to guide our relationship as long as the sun shines and the rivers flow. And that means treaties can evolve based on the original intentions of the two parties that entered into treaty. Our elders negotiated the treaties to ensure that future generations, indeed 7 generations and more, would be respected and protected. This is what First Nations mean when we speak of honoring the spirit and intent of the treaties. Our treaties were not designed to ensure that one party dominates the other. The treaties weren't designed and negotiated to have one party impose its will on the other party. The treaties weren't negotiated, neither are they designed to have one party deprive the other of its rights and interests. Our treaties were not negotiated and designed to have one party impoverish the other party to the agreement, these sacred agreements. Sadly and unfortunately, that has been our history with respect to our treaties. One party has attempted to dominate and impose its will on our people with no good reason to do so. There's absolutely no reason that in a country as rich as this country is, that our people should be as poor as we are. No good reason. So we have an opportunity here during the next 2 days, because our partner, the other party to the agreement, these historic and sacred agreements, is here to participate and engage with us in talking about all of these important matters. The word of the treaty, the spirit and intent, the roles and responsibilities, and mutual benefits of treaty. Those are so very important to all of us. And so we will be listening, observing. We will be witness to some very important discussions. And we look forward to your advice and your guidance, always. Miigwech. Thank you.
Okay, that was Phil Fontaine, who was the former chief of the Assembly of First Nations, followed by Perry Belgrade. Incredibly important to listen to what he had to say, because what he was talking about to a great degree was how First Nations looked at what treaty making was essentially supposed to be like, what it was supposed to do, what it was supposed to accomplish, right? And clearly what he's also saying is that, in fact, is not what happened. All right, so the premises behind treaty making is this: the relationship with Earth is a significant element of Indigenous identity. So there's a lot of material in your readings. I think it was chapter 7 that I firstly gave you, 7 and 8 today, that basically said how important the Earth was, that the life came from the Earth, man came from the Earth, and that created Indigenous identity. On the other hand, right, acquisition of the Earth, i.e. land, is the prime motivation in European settlement. All right, so keep those two premises in mind. The result, of course, is that dichotomy between those two premises is that land rights constitute the principal source of tension between colonizers whose every motivation is to, in fact, acquire the Earth, the land, right? And how that conflicts with Indigenous people who do not see land ownership as a concept, but rather see themselves as stewards of the land for generations going forward, right? That's a really elementary tension, right? Canadian law recognizes 3 methods of recognizing land resources, or land for the purposes of how it's handled, right? And this deals with acquisition from Indigenous peoples. So we have, firstly, unilateral allocation, which is the creation of reserves. And we know that it was fundamentally what happened with respect to with treaties. And treaties, particularly after the Robinson-Huron Treaty of 1850, dealt with that, and that is a fundamental premise of the Indian Act. So keep that in mind. Secondly, you have recognition by the judiciary, right, which is the recognition of Aboriginal rights, inherent rights, right? So that's a really important thing to keep in mind, because we'll be touching upon that with fundamentally Supreme Court of Canada decisions that we'll be talking about. And then, of course, you have allocation by way of agreement between the parties, and those are the treaties themselves. All right, so the first thing, unilateral allocation of reserves. So the reserves are lands set aside for the exclusive use of an Indian, right? And we can't, as derogatory as that term Indian is these days, and I don't like to use it for the most part, but it can't be avoided because it's in the Constitution. Terminology is in legislation such as the Indian Act, so it can't be avoided. So when I refer to that term Indian, I'm referring to it in the context of where it is being found in our readings for the purposes of our discussion. All right, so reserves are land set aside for the use of Indian bands. Bands are a creation of the Indian Act. It's a white man's creation. All right. Bands have the use and possession of reserves on a collective basis, the collective basis being the members of the bands themselves, not individual members of the bands. Right? The Indian Act does not allow for the granting to the use of reserve lands to non-members of the band. Okay, so keep that in mind. It's important, right? Possession of reserves usually belongs to one band. That's the normal course of events. But however, one band can own or possess, not own, but possess more than one reserve. And on the converse of that, a reserve can be possessed by more than one band. So while it's one-on-one, for the most part, there is some deviation from that particular formula. Not all bands have possession of a reserve. Some of them have what's called a settlement, right? A settlement is a lesser kind of possessory right than is a band. A band cannot create a reserve unilaterally, right? It has to be created by the federal government under the Indian Act. And a band cannot enlarge the acreage or the area of the reserve itself. The band has no right to do that. It can't, for instance, say, hey, you know what, outside of Garden River, there's a fair chunk of land going north that we'd like to acquire to add into the reserve. It can't do that. Right? It's just not allowable. Importantly, possession does not mean ownership. Right? Ownership, when treaties are negotiated, and this goes back, all the way again to Robinson-Huron, which was the first template for the number of treaties dealing with the acquisition of Indian territory and the creation of reserves. Right? Possession does not mean ownership. It means basically the right to be on the land. Ownership remains with the state or the crown, and that's what we call it in Canada, the crown. Right? Under the Constitution, Section 92, the province has jurisdiction over lands. Right? So again, you got to remember John A. Macdonald and the boys back in 1864 at the Charlottetown Conference when they decided, this brand new country of Canada is going to have these powers, these particular jurisdictions found in Section 91 of what was the BNA Act, and the provinces will have their authority under Section 92. And what were to become the leaders of what were the 4 colonies to become 4 provinces, Nova Scotia, New Brunswick, Quebec, and Ontario, what they agreed to in 1864 was that jurisdiction over land and the dealings with land and things like mineral rights and ownerships of lands, those kind of things fundamentally would be a provincial responsibility, right? That's important to keep in mind, right? Provinces also, so essentially, when reserves are created, the provinces own the land under the reserves, and they then become the owner of the lands, the outright owner of the lands for the Indian territory that is, the remainder of the treaty lands, right, that aren't the reserves, right? And, it's almost always in the hands of the provincial crown. So when you search title for any property in Ontario, you can go down to the registry office, which is beside the courthouse at 426 Queen Street East on Queen Street, and there's a registry office there. And I guarantee you that for those of you who live in houses in Sault Ste. Marie with your parents or on your own, or rent houses in Sault Ste. Marie, what have you, that you will be able to go there, right? And you will be able to find what's called the Crown Grant of land, that was created by the signing of a treaty. So it doesn't matter whether your house is on Huron Street or it's on Wellington or it's on some other Central Creek or whatever it's going to be in town. No matter where it is in town, you will be able to find that particular parcel of your house and the documents related to it in the registry office in downtown Sault Ste. Marie, going back to when it was acquired under treaty by the Crown. Right? Now, having said that, because the federal governments are responsible for management and control of the reserves under 9124 of the Constitution, right, then you have a bit of a conflict because you have the provinces who have the jurisdiction over the lands, but you have the feds who have the jurisdiction over the reserves. So what happens for the most part is that for those lands that are under the reserve, right, the actual ownership of those lands, they would in fact be transferred to the federal government. All right, so the bulk of the territory still remains with the province, the provincial grant, but the federal government will have the ownership of the Crown lands under the reserves themselves. Resources tend to stay with the provinces. So, when the Fathers Confederation divvied up the jurisdictions back in the day, the resources were going to be provincial, mineral rights, natural gas rights, those kind of things. They stay with the provinces, and that's who has to deal with them going forward. All right. Now, if a band is on a settlement and not a reserve, then it's a whole different scenario. The band council, that is a function of the Indian Act, doesn't get to exercise the same power over the band that they do on a reserve, right? So the structure that's in place for band councils and chiefs and elections of band councils, it's very much based on the Municipal Act, right? The same act that created the city of Sault Ste. Marie. So, for instance, there is a Ontario piece of legislation called the City of Sault Ste. Marie Act. And before that, there was the Town of Sault Ste. Marie Act. All right. So that's a piece of provincial legislation. And, the City of Sault Ste. Marie has to follow the mandate of the Municipal Act of Ontario. And that basically sets out how people, for instance, the wards are created, how councillors are elected to those wards, how they report to a mayor, right? Well, it's exactly the same system, almost exactly the same system for bands. Bands are created on the same premise. However, if it's a settlement, then you don't have the same structure. You don't have the same regulatory authority like a municipality does over settlement lands. So, those Indians who are on settlement lands don't get to participate in resources, right? And they have no continuing guarantee of possession of the settlement lands, whereas band councils do have a permanent, ongoing guarantee of the reserve possessory rights.
Sir, I hate to bother to interrupt, but I have a question because I was how do you say researching before the Royal Proclamation of 1867, and before back then it was King Edward, I think, who was the one that signed the Royal Proclamation. And back in the day when they did treaties and such with people, they only usually did it, say, with India. Back in the day with India when they treated with India because India was rich with resources, and they found that the people from India were really, really intelligent. I don't understand how is it that when King Edward treated with India as compared to treating with the First Nations people of Canada, how come in India that they don't have band councils and they didn't divide up their land and they didn't sell off India land like they did to Canada?
Okay.
Why is there such a difference in the way? I mean, yeah, they said that Canadian First Nations people were savage and da da da. But the thing is, though, is that it's still the First Nations people's land. And I just don't see how to this day they got away with stealing it. Like there was no negotiations, no contract. To me, this treaty between the First Nations people and the king was basically stealing everything from them and just giving them a little bit and saying, you know what, go starve to death over, say, in the prairie somewhere. I know you have no food. Almost what they did to the Scottish people and the Irish people. They did the same thing to the First Nations people, but then turned around and said, oh, yeah, we'll treat with you guys. And we'll, like, I just don't understand this whole concept of how it got this bad in Canada for the First Nations people.
Well, I mean, that's the whole point of this course. So we're gonna hopefully you'll understand that going through the course. So it was King George the Third and the Royal Proclamation 1763. And if you're trying to see what the different, well, actually, other people have raised their hands. So hang on a sec. Let's see if they want to. Carolina, you want to address Michelle's question?
Yes, it just made me think of maybe not the difference between like Scotland and Ireland, like you mentioned, but like with India versus Canada, it made me think of that there was no market established in Canada, so it gave them that upper hand, and they really wanted that land because of that, because they wanted to establish an economic market where they can start from scratch and start trading and building whatever they want. Where when they went to India, there was already established economic activity. So it was just easier for them to approach that. That was just a thought I had.
No, listen, the establishment of a culture that was well established and well recognized is really important. Pinder, do you want to talk to that?
Yeah, I just want to address Michelle's question. Like, as much as I know, the treatment with India is like more from the Britain, like England people. So like, it's not like more from the Canada side. So like England did try to do the same thing, like they rule over like for so many years on India. But the thing is like India get its independence in 1947 by fighting against them, and like so many people get like die in that fight. So that's the only, like, because like people in India did understand the way British want to establish it, so that's why they all stand against it, and they try their best to send the British out of India. But the thing is like it's not like more Canadian side government who did anything to it. It's like more from the England side.
Yeah, thank you. And we're going to talk about this in a little bit in a few seconds. But in dealing with what did the English or the British find when they came here versus what India was a colony, but what they found in India. India, they when they went to India to colonize, it was for economic purposes, but they found a very even on their standards a very advanced civilization, one that they widely recognized, and one that they didn't see as needing to the same degree to be civilized to some degree. Whereas when they came to North America, they, even though the Royal Proclamation, which is considered to be the Magna Carta of Indian rights, they did recognize that there were some nations here, but that changed over the course of time as a function of the implementation of terra nullius, which we'll talk about as well. But so different cultures, different purposes to a great degree. So we'll get there. But thanks, Michelle. I appreciate the point, because how we got from 300 years ago to where we are now is hopefully what I'm going to teach you. From what I've already been teaching you and what we have left in the course. So we'll get there. The Indian Act allows resources to be managed under the says Department of Aboriginal Affairs, that's now Indigenous Affairs, rather than the band. So again, it's very paternalistic, right? But anything that the Indian agent, who does still exist, does for the band must be for the benefit of the band. And we'll talk about that when we get to the Supreme Court decision in Giron a little bit later. Having said that, however, the consent of the band is not necessary for the minister to grant licenses for resource extraction, right? But having said that, the Supreme Court of Canada has also put into place fiduciary duties and the duty to consent and accommodate, which we'll talk about as well, all right? So what is possession under the Indian Act, Section 20? And that's what the Indian Act actually says. So no Indian is lawfully in possession of land in a reserve unless with the approval of the minister, possession of the land has been allotted to him by the council of the band. And subsection 2 basically says that the band councils can issue certificates of possession. What that means is that, if you're living on a reserve, right? So you're a member of the band, you're living on a reserve, what you are given is a certificate by the band council to live in a particular house. All right, and the houses, basically are there to be, for the most part, leased by the band council, right? Nobody owns them, right? Because the land itself is owned by the federal crown. So it's pretty important. So all the band is given as a function of Section 20 is the right to grant possession of the land to individual members of the band. All right. The band may allocate possession of part of the reserve to a band member with a certificate. That's what I just said. All right. Concepts to ownership, right? So the right of a certificate of possession can be transferred from one party to another or by a last will and testament. So that's very similar to what happens in wills, in non-Indigenous circumstances. But, when you pass property under a will in, non-Indigenous lands, non-treaty lands, then, the ownership is transferring. In case of, possessory title on reserves, it's only a possessory title that is passing, right? The Minister of Indian Affairs can actually void a bequest. So, for instance, if somebody left, left their possessory right to a house, on a reserve to somebody who was outside the band itself, who had absolutely no Indigenous roots whatsoever, right? Then I guarantee you that both the Indian agent and the ministry would set aside that passage of the certificate of ownership by way of a will, right? They will not allow these kind of things to take place that contravene the act itself. So the band can build houses on reserve and lease them, but they do not create Section 20 rights, right? Possessory rights are not protected under provincial family law, which is really important because, for everybody who doesn't live on a reserve, in domestic situations who are married, common law has a whole different set of rules for matrimonial property than do married people. Most people, and I teach family law, most people don't get that. They think that because common law is such a common situation these days, that they have all the same rights as married couple. Well, they don't. Matter of fact, while their support rights and custody rights of children are very similar, ownership rights in lands are completely different. So it's only, the division and equalization of property under family law in Ontario, this is for non-reserve lands, is between married parties, not between those who aren't. Having said that, however, the possessory rights to a house on a reserve is not something that is subject, is likewise to be divided under the terms of, in Ontario, the Family Law Act. All right, the Indian Act, Section 28, right, which basically says that subject to Section 2, which is dealing with ministered issued permits, any deed, lease, contract, instrument, or document of any kind by which a member of a band purports to permit a person other than a member of the band to occupy on that. So basically we're talking about their possessory right of a house on a reserve. Any transfer of that right to anybody outside the band is void unless it's otherwise agreed to by the minister, and that would be through the authority of the band council. All right. Again, voids any grant of band rights to a non-member of the band. However, there are rights that can be transferred to people outside the band for specific purposes, things like occupation permits, surrenders, and expropriation, and I'll tell you what those are. All right, so occupation permits are quite simply this. If on the reserve the band wants to install a water treatment system or a sewage treatment system or what have you, right, then an outside party, engineering firm, a non-Indigenous engineering firm from Sault Ste. Marie can be given a permit to, in fact, be on band lands for the purposes, for a short period of time, to do the work of whatever the engineering is going to be required for either the water or the sewage treatment plant. Right, so that's pretty straightforward. Surrender. So surrender of reserve lands can take place. All right, so some reserves are very, very large. Right, so the surrender of those lands, which means the band council giving up, those lands to be part of the reserve. These are talking about surrendering lands to no longer be part of the reserve, which means they become the Crown grant, for all the other treaty lands that were transferred during a treaty, right? That happens, quite a bit. It happens particularly for those, those reserves that are close to urban areas, where in fact, for some reason, whether it be a factory or it could be a subdivision or what have you, It could be, if the band thinks it's in their best interest to sell off a piece of the reserve and get the income from the sale of that, or to have it leased out by the Crown and then get the revenue from it, that has to take place by a surrender, and it can be done, and it's been authorized ever since the Royal Proclamation. Right? So King George III put that in there in 1763. Right, the Indian Act, Section 37. So this simply means that lands on a reserve cannot be sold unless they've been absolutely surrendered by the reserve, by the band council. All right, so in fact, that has, nothing can happen with lands that are reserve lands until they're totally surrendered firstly. Okay, that's really important to remember, right? It requires, in order for this to happen, it requires the majority of the band members. So what happens is that the band council calls a meeting together of all those in the band who have voting rights, and they hold a vote, just like any other democratic vote, essentially. And if the majority agrees to surrender those lands for whatever purpose, a sale or a lease, then that will take place. Right, but remember, and again, this is the Royal Proclamation of 1763 and the Indian Act, that only the federal government can obtain that surrender, right? And then the federal government will do whatever a fiduciary duty requires them to do for the benefit of the band that just surrendered those lands, all right? And remember, when the band does surrender parts of the reserve for whatever purposes, it's not an extinguishment of the band's rights, in those lands, but only an extinguishment of their right of possession of those lands. Okay, so again, because the band never owns those lands, they're just simply giving up their possessory rights to those lands, and that's what the absolute surrender is all about. And once that's gone, and this is a terminology used by the courts, the federal government or the provincial government, whichever crown has those underlying lands, become liberated, meaning they're free from those interests of the indigenous peoples who had the reserved lands, right? If lands are to be sold, then the surrender must take place first and be absolute, right? Which means that, that they have to be given up totally. If it's not absolute, right, then the reserve remains in place. So that's important to remember, basically. With respect to fiduciary duties and reserves, right? So bands have questioned the federal government's motives and methods in the surrender of lands over the years, right? Because again, of course, the federal government is the one that has control of this process. So this was a really important decision. It's the Supreme Court of Canada, that's what SCC stands for, and the Guerin decision. And what that did is it established the concept of the federal government's fiduciary duty with respect to surrendered lands. And so what happened in this case, and this is a reserve abutting the city of Vancouver. So this is really, really valuable land in British Columbia, right next to the biggest city, basically. So part of the reserves of the Musqueam Band in Vancouver were surrendered for what was looked to be a long-term lease for a golf club. It ended up being the Shaughnessy Golf Club, which is an incredibly pricey, exclusive golf club in the city of Vancouver. So the purpose of it was this, that the golf club, they came to the band council and they said, we'd like to acquire, this chunk of your reserve lands for the purposes of creating a golf club resort kind of thing. And the band council agreed with that because they knew that they would, have the chance of getting income from the acquisition and or lease of those lands to the golf club. So what they did is they told the Indian agent to negotiate for them a favorable lease with the golf club, right? But in order for that to take place, again, they had to absolutely give up their possessory rights in those lands to become the golf club. So they surrendered that part of the reserve that was to become the golf club. The federal government then, of course, was liberated from the reserve rights, and the federal government could then enter into a lease with the golf club. And it did. But what happened is that the Indian agent who negotiated the lease with the golf club didn't tell the band, the truth about the terms of the lease. Matter of fact, the Indian agent misled the band as to how beneficial the lease was to the golf club, and contrary to, the amount of rent they should have properly received for what in fact was this very expensive piece of real estate. So later, and this took years and years for this to happen, eventually the lease came to the attention of the band. So the Indian agent and the federal government didn't even give them a copy of the lease for 10 years, right after this surrender took place. And once the band got a hold of it and they looked at it, they realized that they were essentially ripped off. That the rent that they received from the golf club through the federal government was a lot less than what it should have been based upon the value of those lands. So it went all the way to the Supreme Court of Canada, and the Supreme Court of Canada said, look, the federal government, particularly obviously its agent, the Indian agent, had a fiduciary duty to look after the interests of the band when negotiating that lease with the Shaughnessy Golf Club. And as a function of that, the court ruled that the federal government owed the band, the Musqueam band in Vancouver, basically $10 million in damages. And that $10 million was the estimated loss of the value of what the appropriate cost to the Shaughnessy Golf Club should have been, right, in that very expensive piece of real estate to what they actually paid because the Indian agent negotiated such a poor deal for the Indian band. I guarantee you the Indian agent had a really nice lifetime membership to the golf club. I guarantee you that happened. Anyway, and so what that established is this, incredibly importantly, for the first time at the Supreme Court level, it established that the federal government, as a fiduciary to Indian bands on First Nations reserves, that they must always act in the best interests of the beneficiary, being the band council. They must avoid all conflicts of interest, right? So again, while I'm telling you that the Indian agent likely had a membership of the golf club given to him in perpetuity, that would have clearly been a conflict. He's getting a benefit to himself, and I guarantee you he got that benefit. They must, the fiduciary must account for the management of monies that are being handled for them, right, through this kind of relationship, right? And the federal government cannot unilaterally renounce its responsibility to, in fact, carry out its fiduciary obligations. All right. However, having said that, over the course of time, right, courts have been reluctant to find a fiduciary duty. This is even after the Guerin decision. Courts of a lower level. So in Ontario, it would be the Superior Court of Justice, in British Columbia, where Guerin was decided, it would have been the Supreme Court of British Columbia. Even when other bands have come before the courts to say, look, we don't think the federal government has treated us properly regarding their fiduciary duty, courts have still been relatively reluctant to provide for damages in that case, right? Except when it deals with surrender. Surrender is a pretty clear case. The other thing to remember, of course, is that, and this is incredibly important, is that limitation periods apply in cases where a fiduciary duty is raised. You guys, some of you guys are 3 and 4th year jury students. You should know the answer to this. What is a limitation period when it comes to civil litigation? Anybody?
Sir, if I can, I think what you mean is a statutory limitation is what the government puts on certain crimes. Like, say, if you kill somebody, the statute of limitations is forever. If you steal a car or whatever, isn't it? The statute of limitation is 2 years, something like that. Is that what you mean? Is that the example that you're looking for?
You're close. You're talking about in criminal cases. We don't in Canada. We have limitation periods. If it's a summary conviction offense, 6 months limitation. If it's indictable, there's no limitation. That's what we do in Canada. But when in the civil context, it's this, and every province has its own limitations act. So in Ontario, and I'm not sure what it is in British Columbia, but it's probably pretty similar. You have 2 years to start a lawsuit for any wrong that has been done to you, right, that comes to your attention. So for instance, if it was a 2-year limitation on the Musqueam band in British Columbia, they would have had 2 years from the day they learned that when they finally got the copy of the lease, that they learned that they were essentially being ripped off by the Indian agent, right? So we'll say that took place on February the 1st of 2002, right? Well, they would have had then to January the 31st of 2004 to issue an action seeking damages for, the loss of their rental income. That's a limitation period. And if you miss that date, doesn't matter really what your reasons are, but if you miss that date, your opportunity to sue is gone, right? And so it's important to realize that even though we're dealing with things like fiduciary duties and surrender of lands and what have you in Canada, limitation periods apply, when it deals with fiduciary duty. So, if some band finds out that they've been mistreated somehow by the federal government in any of the dealings with them, that could give rise to a claim for damages for loss of income or property, they have 2 years to bring an action for it. So that's really important to remember. It's obviously in the Guerin case, the Shaughnessy Golf Club case, they met the limitation period, which means that they did issue an action within 2 years from learning that their lease was terribly drafted in favor of the golf club and not in their favor. Okay, so let's go back again. This is again a more historical perspective again, but it's important. The theory of Aboriginal rights. All right. So and keep this in mind with Michelle's question regarding the India as a dominion and North America. All right, because this is where it comes into play. So what are the laws that apply to colonies? Colonies being whatever the colonizer. This could be England, it could be Spain, it could be Holland, it could be Germany. In Portugal, there's a number of European countries that were colonizers, right? And the same law applies because these are international laws. So there was two choices that applied to the colonies as to what law was going to apply in those colonies. One deals with colonies of conquest, and the other deals with colonies of settlement. All right, so those two terms are important to remember. So a colony of conquest is where, we'll talk about England and North America because that's what we're dealing with, or Britain and North America. So, when lands are acquired from other European powers, right, they recognize each other to a great degree, then the British would allow the former legal system to continue, right? That's called the doctrine of continuity. So in North America, that essentially happened in two places. So, after the 7 Years' War and the Treaty of Paris in 1760-61, where France decided that it was no longer going to occupy parts of North America, when Britain, when they accepted that deal, basically they did acknowledge that, for the area of Louisiana, all right, Louisiana Purchase wasn't part of the United States at that time, and Quebec, right, in both of those areas, the British said, the French Civil Code will remain in place. The doctrine of continuity would apply. And it still does. You still have the French Civil Code in Louisiana and the French Civil Code in Quebec. We've talked about that earlier. That's when it comes to civil matters, not criminal, but civil matters, right? The colony of settlement is this. When lands aren't acquired from other European powers, then Britain imposed its own legal system. And that's what happened in North America. Right? Apart from whatever that allocation was for the French, all of North America, now we're not talking about Mexico because Britain didn't colonize Mexico, but it did what became the United States and Canada, right? Apart from Louisiana and Quebec, it imposed the English legal system. The English common law system is essentially what it imposed. We've talked about that before, and that's what was put in place, and that's what is still in place. So that's the colony of settlement, all right? Okay, so let's talk about how these theories have been put in place in the Indigenous context in Canada, right? And so the first case that really dealt with Aboriginal title was a case called St. Catherine's Milling of 1888, and was heard before the Privy Council in London. Now, we've talked about this earlier. Why would this be a Canadian case heard before the Privy Council? Anybody? It's actually the Judicial Council of the Privy Council. Anybody understand why was this case heard in London, right? Elizabeth?
So this is before the highest level of court was moved to the Supreme Court of Canada because part of the Constitution hadn't been made yet.
Right. So do you know what year that was?
I'm blanking on that.
Okay. Good answer. 1949. Okay. So in Canada, the highest court, the last resort of appeal in Canada for all cases, was the Privy Council in London, which is a House of Lords committee, up until 1949. So you could take a case all the way to the Supreme Court of Canada before that time, and if you still weren't happy with the result in the Supreme Court, off to London you would go. Right, and I think I mentioned this before, there are still jurisdictions that were British colonies that still go to the Privy Council. So Jamaica and Aruba, Caribbean nations to a great degree, they still have a Supreme Court, but if you're not happy with their Supreme Court decisions, off to London you still go, even these days. Okay, not Barbados. Barbados is cutting off all relations to the Crown. But having said that, we didn't cut those off until, for the purposes of judicial review, until 1949. So what the Privy Council ruled, basically, this deals with Treaty 3, which is for the most part northwestern Ontario, right? And the question was, it was a contest between the federal government and the federal government saying, well, we have control over lands, Indians, and lands reserved to Indians under Section 9124 of the Constitution, and so therefore we have jurisdiction over the resources. These cases all deal with money, right? They almost always deal with money. So we have power, jurisdiction over the lands of Treaty 3 and its resources, the minerals and mining and all kinds of things which were incredibly valuable at the time and still are. And the province said, well, no, that's not the case. I mean, Section 92 of the Constitution says that natural resources and property are a provincial jurisdiction. And so, what happened was that the provinces and the feds took it all the way to the Privy Council to decide the case. And basically, it ruled in favor of the provinces. So the Privy Council was pro-provincial to a great degree, right? It also indicated at the same time, as part of Aboriginal rights, that the rights of Indigenous peoples could only be found those in the Royal Proclamation, all right? Aboriginal title, again, and this goes back to what we were talking about earlier, is not a function, again, of ownership rights. It's called, and this comes from the St. Catherine's Milling case, Aboriginal title is personal and usufructory, which is a very odd word. I find it to be a very odd word, which simply means that the title itself is totally dependent upon the will of the sovereign or the will of the crown, right? So again, it just reemphasizes that it's not an ownership right. It's a possessory right. The title, the ownership itself remains with the crown, right? Now, fast forward almost 100 years. And this is how long it took to get to the Supreme Court again over Indigenous rights. Any idea why that was? We touched this last week. Why did it take to 1973 for Indigenous Canadians to get another case to the Supreme Court of Canada? Anybody? Because the Indian Act in the early part of the 20th century took away from Indigenous Canadians the right to hire lawyers. The Indian Act actually said you do not and cannot hire lawyers to protect your rights. And it wasn't until the early 1960s that right was reestablished by an amendment to the Indian Act, right? And then, it takes 7 to 8 years to get a case before the Supreme Court of Canada. So, relatively soon after the rights to lawyers was established, a case came up called Calder, and within 7 to 8 years, it made it to the Supreme Court of Canada. So this is how long it took, right? And this case varied from the St. Catherine's case that basically said that Aboriginal rights can exist independently from the Royal Proclamation, right? So St. Catherine said that all Indigenous rights are found in the Proclamation. The Supreme Court now said, remember, this is post-1949, so the Supreme Court of Canada is the supreme law of the land, right? It now said that Aboriginal rights can go beyond what is found in the Royal Proclamation. That's a big deal, right? And what it also said is that they are common law rights can be established. Remember, of course, now because it's a colony, basically a colonization, that its continuity is that it's there to have the English law in place, right? So the English common law is in place. And what the court is basically saying is that Indigenous Canadians, like all Canadians, have English common law rights, in addition to what they historically have had under the Royal Proclamation. Following up, now another 30 years, we have a couple of Supreme Court decisions in Marshall and Sappier, 2005 and 6, which basically says this, that Aboriginal rights are not solely dependent upon the adoption of common law and of the adoption of an Aboriginal legal system. So what it's basically saying now is it's even going farther. So Aboriginal rights aren't just in the Royal Proclamation, they aren't just a common law, they can also be a function of an Aboriginal legal system that stands on its own. Right. In order, however, to rely upon Aboriginal legal rights, courts look to this is really important, the factual existence of a practice at the effective date of occupation or the establishment of British sovereignty. So what that essentially means is this: if you're going to rely upon, and many Indigenous Canadians had to rely upon this to save themselves from charges under various statutes, federally and provincially, to basically say that my rights are Indigenous rights and not those for other Canadians. In order to do that, they had to establish a factual record of what their rights were at the time of contact or British sovereignty, right? A monumental job for historians, and we've talked about this. And what's happened is the Supreme Court now sees historical facts as the foundation for what are constitutional rights, embodied in Section 35 of the Constitution. And we've talked about Section 35, and here's what that says. So 35(1), the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. That's incredibly important. What that is doing is it's saying in the Constitution, it's saying we now constitutionalize, which means it's much more than just a statutory right, it's a constitutional right. We now recognize the existing Aboriginal treaty rights of the Aboriginal peoples of Canada, right? And when it says existing, right, that's a really important thing to recognize, is because when it was first interpreted after this section came into effect in 1985, although it was enacted in 1982, when it was first looked at and the word existing was in there, everybody kind of looked at it and said, okay, so the rights were really only those in place in 1982 when Section 35 was enacted. But the courts over the course of time since then have, broadened the word existing to mean exactly that, existing for all time. So that's important to keep in mind, right? So constitutionalizing a right is incredibly important because it can't be taken away. But what the court has said is that the practice, custom, or tradition must be an integral part of the distinctive culture of the people to be considered an Aboriginal right. So remember, if somebody, we'll talk about Donald Marshall in a few minutes, if somebody is charged with, usually it's a regulatory offense, fishing out of season or fishing with the wrong size nets or hunting out of season, whatever it may well be. And we talked about, the Powley decision, in Sault Ste. Marie regarding him shooting moose, and the establishment of Métis rights, right? Well, it's the same kind of thing. But here we're talking about if somebody, is charged with an offense, hunting out of season, right? And they're hunting out of season and they say, well, that's because we have the right to do that. We always have had the right to do that. We're hunting whatever game it was, right? In order for that defense to work, to be able to rely upon Aboriginal law existing at the time of contact, they have to bring in, this is the defense, has to bring in an historian who will say that yes, in 1652, at the point of contact for Treaty 3 in Northwestern Ontario, right, it was an Aboriginal practice to hunt moose. That's the kind of specificity that Indigenous defendants have to bring to a court, and they still do, right? So it's really, really important to remember this, right? The 1997 decision of Delmagook, right, incredibly important. There's one of you in one of the group presentations that you're doing at the end of the semester is on the last year's railway protests, the Mohawks in Ontario, as a function of the lands in British Columbia to put a stop to the pipeline that was at issue of the day. The Indigenous peoples of the area, the Wet'suwet'en was the First Nation. They took the position, relying upon Delmagook, that they had the absolute right to stop a pipeline from going through their lands. And this is why. So what this decision basically says is that Aboriginal rights flow from two sources: prior occupation of the land by Indigenous peoples, which again is constitutionally recognized by Section 35, or the recognition of pre-existing indigenous systems, the doctrine of continuity, all right, which is pre-contact. Okay, so what is basically saying is that, you know, we can do whatever we were able to do, and we have the same authority over lands that we occupy, not, you know, and in the case of the Wet'suwet'en, it wasn't treaty lands, it was in British Columbia. And remember, British Columbia didn't enter into treaties. They weren't part of the 11 number treaties after Robinson-Huron. You know, the treaties that went in place between 1871 and 1921, essentially. They didn't join those treaties because they believed in the concept of terra nullius. So you have the Wet'suwet'en in British Columbia who basically said, we have the authority over whether pipelines go through our lands because we've always had the authority over these lands, all right, based on Delmaguk, all right? Who owns Aboriginal rights, right? Well, they belong to a collective. They belong to the group. So individual members of a band, you know, or an indigenous nation cannot hold rights, and individuals cannot surrender those rights. Only the band can. Who is seen as a collective under the Indian Act? Well, again, bands are, right? So before the Indian Act, you know, you had tribes and nations and what have you, and sometimes bands, but not very often. But when the Indian Act was put into place in 1876, the entire political governance structure of Indian bands was put into the Indian Act and created that municipal system of governance called the band structure with a chief and band councillors. What about the Métis? Well, they really didn't have bands per se because, again, they're not subject to the Indian Act, right? And they, you know, we know that Métis aren't, you know, Section 1 or Section 2, Section 6.1 or 6.2 Indians with status under the Indian Act. We know that. They're separate and apart from that. We know about the Métis, they didn't have bands. And it's really important to remember, of course, as well, is that the right of being Métis and having those traditional lands, they can't rely upon all those tests I went through, the St. Catharines Milling and Calder and Sapieha and what have you. They can't rely upon those tests because they can't rely upon what rights they had at the time of contact or British sovereignty because they did not exist, right? The Métis Nation did not come to be. Métis Indigenous persons in Canada did not come to exist until after conquest or contact, right? Where in fact, you had the commingling of blood, you know, with first the French, but primarily the British and fundamentally the Scottish as a function of the Hudson's Bay Company. All right. So again, for Métis, the Supreme Court's focus has been on the historic community, you know, and it precludes groups formed thereafter. So that for those purposes, Métis do not come into the definition of Aboriginal rights unless they're arguing, according to Powley, that they have the rights that they can establish according to that particular formula, all right? How does someone belong to a group or a band? Well, the membership of a band is basically provided by the group, you know, the rules of the group itself. So the band itself sets its own rules of membership. It doesn't necessarily have to be those who have status under the Indian Act. You know, you don't have to have status to belong to a band, right? Section 10 of the Act permits creation of a membership code which can enable non-Indians to be members of a band, right? And this is a fairly common thing. There's lots and lots of intermarriage with, you know, members of the band with those who are non-Indigenous, and they can still be members of the band as long as the rules of the band allow for that. And the band council approves it. They have to apply nonetheless. What are Aboriginal rights, right? So again, Delmaguk basically says that Aboriginal title is the exclusive use of a given territory. And this is, again, goes back to, you know, the pipeline issue. They, you know, the Wet'suwet'en stood on the ground of Delmaguk saying, we have the exclusive right over this territory. We did not give it up in a treaty, right? So it's exclusively ours, and you can't build this pipeline without our approval. And the holder of that Aboriginal title has the right to engage in activity on those lands. Now it says any activity, but the courts have narrowed that down somewhat, right? So Aboriginal title does not permit activities that are incompatible with traditional activities on which historical occupation of the land is based, historical Aboriginal occupation, things like strip mining or clear cutting of timber, what have you, which destroy, right? Destroy the ability to hunt and trap, those kind of things. They aren't allowed. That's not part of exclusive rights, basically. So the rights were basically aimed at activities which were traditionally exercised by Indigenous peoples pre-contact or at British sovereignty, which again always requires a tremendous amount of historical evidence, right? The Sparrow decision in 1990, it recognized Indigenous rights to fish, but not on a commercial basis. Okay, the right was constitutionalized by section 35 because obviously it was after the Constitution was enacted, right? This case relied upon the word existing as at 1982, but did indicate that the right could evolve over time as long as the right was never extinguished. Again, when rights are subject to litigation, so somebody is charged with an offense, the burden of those seeking to protect the right is the one that has to provide the historical evidence. What almost always happens because of these kind of cases and the importance of these kind of cases for Indigenous rights Canada-wide is when somebody is charged with an offense where they're, with an offense of hunting or trapping or fishing out of season or whatever it may well be, right? The call will go out to, the Assembly of First Nations, whoever it's going to be, to fundraise, the fees required to raise that historical defense, right? So it's really a collective effort. And it's almost always required because no individual person, right, Indigenous or even non-Indigenous for that matter, can afford that kind of defense, to afford that kind of expert testimony. Here's the test for the recognition of a right. The practice in question must be of fundamental importance to the Indigenous society in question and must not be merely accessory. The practice may evolve over time, but it must not have appeared only following European contact. It is not necessary that the practice be unique to the people before the court, as long as it constitutes a characteristic element of the culture of the people. So again, that's what the historian called as an expert for the defense has to basically provide. Therefore, every trial of Aboriginal rights must include long expert testimonies on the subject of the Indigenous culture of the past. All right, here's a brief video on Aboriginal rights in British Columbia.
In the Canadian province of British Columbia, First Nations people dwelling on the banks of the Fraser River are finding themselves increasingly criminalized by the state for merely catching fish to feed their young ones, just like their ancestors did for thousands of years. Joshua Blakeney reports.
Despite the fact that the colonial government of Canada has signed no treaty with the Aboriginal coastal Salish people who reside on the banks of British Columbia's mighty Fraser River, the state claims jurisdiction over all the natural resources and aquatic life of the Western Canadian province. Thus, Canadian First Nations in the region have found themselves subject to criminal prosecutions for merely catching fish to feed their children, in a way that their people have been doing for hundreds, if not thousands of years.
I'm getting charged, going to jail. I was one of the first ones to go to jail for fishing without a license, possessing of fish to feed my family.
What makes it right for Canada to criminalize me for something that my family and my ancestors have done for thousands and thousands of years? Since time immemorial, we've had fish as a part of our diets. What makes it right to use the law, the invented laws of Canada, and send me off into first jail and then court year after year after year?
Section 35 of the Canadian Constitution purports to recognize and affirm Aboriginal title and sovereignty. Yet, when those Indigenous peoples who have never negotiated a treaty with the Canadian state seek to assert sovereignty over the natural riches in their territories, they find themselves smeared by establishment journalists as terrorists and criminalized by statesmen who brazenly act in violation of the supreme law of Canada.
Because I lived here for most of my life, and it's been only 7 years And that's a long time. That's my children's lifetime. My children are so upset about this, and so am I, that I cannot just go and get fish without being criminalized.
Canada's Department of Fisheries and Oceans advances environmental arguments to justify imposing stringent restrictions on indigenous fishers. However, the ubiquity of wild salmon and the deftness of the indigenous fishers who catch them poses a challenge to the profits of the white-owned corporate fish farms, which leads some to suspect that the politicians are cynically employing environmental arguments simply to protect the profits of potential political donors in the fish farm lobby.
What's been going on is the Department of Fisheries and Oceans feels they have the right to manage the fish, but they've lost sight of what their objective is. What they're doing is they're trying to manage the indigenous people here to stop them from accessing the food source that we've been accustomed to all our lives.
I compare it to the situation with the buffalo in the late 1800s. The fact that the buffalo were still on the land gave independence to those Indian peoples. So there was a push by the U.S. government, by the railway companies, by the cavalry to end the buffalo herds, because the buffalo herds gave economic independence to the indigenous peoples who for hundreds and thousands of years had derived their livelihood from the buffalo herds. And I see the same thing happening here in British Columbia on the Fraser River and other rivers where the salmon run, that there seems to be a decision to kill off the indigenous wild salmon because it keeps the indigenous people dependent. And we see here in British Columbia the usual very tough story of indigenous people being dispossessed, ending up homeless in the streets, ending up addicted to drugs and such.
The disputes between these indigenous sovereigntists and the Canadian state brings into question the legitimacy and authority of the Canadian state to assert jurisdiction over territories and waters that have never been formally relinquished by the colonized inhabitants of the area. Joshua Blakeney, Press TV, Chiam First Nation.
All right, guys. And so what we're going to do is now we're going to go to the other side of the country, to the Maritimes, and the case of Donald Marshall. Now, I put Marshall's Supreme Court case on Moodle for you, so hopefully some of you have taken a look at it. Does anybody want to give us a quick synopsis of the facts in Marshall? Really important case when it comes to Indigenous rights to sustenance.
Hi, sir. Yeah, I read some of it, and it was basically about his fishing rights. He was prohibited from netting during the closed period and selling fish caught without a license in violation of the federal fishery regulations. Whether he possessed treaty rights to catch and sell the fish exempted him from the compliance with the regulations.
Yeah, excellent. Yeah, that's great. Thanks, Michelle. Yeah, that's very good. It was he actually caught 460 or 70 pounds of eels, and to sell them, on a commercial basis, which the government took the position that the indigenous peoples had no right to do. Marshall's defense was that the treaty entered into, it's one of the original treaties for trade with the Mi'kmaq. He was a member of the Mi'kmaq Nation, which was the only First Nation reference in the Daniels decision, if you remember that, in Nova Scotia. He said that basically he had a right to do it because they had a right to hunt and trap and fish and trade at what were called in the treaty truck houses, which are in fact trading posts. And as a function of having that right to trade at trading posts, he took the position that he did have the right to make a modest living in the sale of these eels. Obviously, 470 pounds of eels is more than what is necessary for the consumption of himself and his family. So here's a brief video that describes the facts in a little more detail.
Trevor Bernard. I'm the executive director with the Member to Band Council. I'm also a lawyer by training. Marshall was arrested for the illegal sale of eels, contrary to the Fisheries Act. My understanding is that it was more or less a test case. In 1985, the Supreme Court of Canada recognized the validity of Mi'kmaq treaties for the first time in the Simon decision. The treaties also contained a trade component, which the Mi'kmaq wanted to have recognized as well. So Marshall was put forward as a test case to have the right to commercial harvesting of fish recognized. So he was charged and I believe lost in all the lower courts, and finally was the right to trade was recognized in the Supreme Court in 1999. It was recognized as a significant victory for the Mi'kmaq and for all treaty peoples for the recognition of the right to I believe the words that the Supreme Court used was the right to a moderate livelihood from the resources of the land and waters. Well, the treaty that was recognized was the Treaty of 1760-61, which was 2 years before the Royal Proclamation. What I understand of history is that the Royal Proclamation was meant to apply to Indigenous nations further west, and the belief was that the Mi'kmaq and the Maliseet, who were the treaty beneficiaries of those treaties, were heading towards extinction, and so there wasn't any need to formalize title issues with them. Well, I was with an organization called the Atlantic Policy Congress of First Nation Chiefs, and I do recall the morning of the decision, a group of chiefs and officials and representatives of the Mi'kmaq had gathered in Halifax to await the decision, and it was an exciting time. I can tell you, it was an exciting morning, and not long afterwards, because the treaties had recognized rights for the Mi'kmaq and the Maliseet, the forum where these issues were discussed were the All Chiefs forums with the Atlantic Policy Congress of First Nation Chiefs, and I can remember the All Chiefs meetings were happening quite frequently to discuss the implications of this important decision. I can remember at the time chiefs were being, and communities were being approached by the Department of Fisheries and Oceans to try to execute interim fishing agreements to, I guess, to ensure the orderly entry into the commercial fishery. The Department of Fisheries and Oceans was buying licenses, buying vessels, and they claimed that the fishery had been, the more lucrative fisheries had been fully subscribed, and so they instituted a buyback program on behalf of the Mi'kmaq and Maliseet. Well, those interim fisheries agreements are still in place. A lot of communities that signed those agreements had gained access, as I said, to the more lucrative fisheries, snow crab, lobster, and they have led to economic benefits for those communities for sure. The actual treaty right to fish is still being negotiated here in Nova Scotia. I can't speak to other provinces, but in Nova Scotia, it's happening under the Gwilmu Maunglusuwahan process.
All right, guys, and I can tell you that, you know, these things, the Marshall decision is back before the courts right now in Atlantic Canada, and the reason is that, and you would have seen it in the news last fall, the Mi'kmaq lobster fishermen, fisher people, I guess, persons, are, you know, have the right to fish, you know, in outside of the season that the non-Indigenous peoples do in the Atlantic Ocean. But there's a real dispute, you know, between the non-Indigenous and the Indigenous peoples over how much lobsters are being caught. right? The non-Indigenous fishermen believe that the Mi'kmaq are extensively overfishing the lobster beds, right? And so there was a lot of dispute between them, angry, damaging of property and boats between them last fall. It's in the courts now, and it'll certainly be back in the news again, in the upcoming season, because it hasn't been resolved yet. So, that just shows you, that these things just don't go away to a great degree, right? So that's what we've got with Marshall. We'll also be talking about Donald Marshall when it comes to criminal cases in the next couple of weeks, because Donald Marshall is widely recognized as the first wrongly convicted person in Canada. And he was convicted based on systemic racism, and it's the same Donald Marshall as in this case. So he's a pretty famous guy in legal circles, and one that is now, he passed away a few years ago, but certainly very, very well known for both Indigenous rights and the rights of the wrongly convicted. All right, we just have a few slides, 20 odd some slides here now. I'm dealing with, in this particular section of the lecture, on the specific treaty tribunal, basically. Specific claims tribunal, it's called. Oops, what happened here? Let's try this again. There you go. Yeah, specific claims. So what specific claims are, basically, are where Indigenous peoples who have entered into a treaty with the federal government decide that the treaty has somehow been violated, and they want to go to court to enforce its terms or its provisions. These are the treaties that have been put in place over the course of British contact with Indigenous peoples in Canada. The government of Canada recognizes 70 historic treaties between 1701 and 1923, and here's what they are. The treaties of peace and neutrality, peace and friendship, Upper Canada land surrenders and the Williams treaties, the Robinson and Douglas treaties, which we've already talked about, Robinson Huron, Robinson Superior, and the numbered treaties. All right, and the Robinson and Douglas treaties were the ones that essentially are the template for the numbered treaties, the 11 numbered treaties that created the country that Macdonald confederated to a great degree. The treaties form the basis of contractual obligations between Canada and 364 First Nations of approximately 600,000 Indigenous peoples. All right. So the historic treaties are all the treaties that are basically lumped together and considered to have been in place prior to 1975. And 1975 was the enactment of the James Bay Cree Treaty in Quebec and the Arctic Circle, the Inuit. So we'll talk about that when we talk about modern treaties, because that's considered to be the first modern treaty. But all the other treaties, including the numbered treaties up until 1975, they did this. Land was set aside for reserves. We know that. Annuities were put in place, so each member of the band were granted a annuity for life. The annuities ranged anywhere between $2 and $5 a year. They've never changed to a great degree. So the annuity in the Robinson Huron Treaty is $4 per year. It was that in 1850. It's that in 2021. Although there's a monumental piece of litigation that's ongoing between the Robinson Huron Treaty peoples and the province of Ontario with respect to the value of that annuity, because the chiefs who entered into that treaty back in 1750 very wisely connected the value of the annuity to the mineral extractions that would take place by the Crown on the lands that became the treaty lands apart from the reserves, right? And the provincial government never paid for that, or the federal government never paid for that, between the two of them actually. And it was decided about 2 years ago in the Ontario Superior Court that in fact those annuities were owed for the past 250 years. And so now they're working on a process to calculate how much that's worth. So my son-in-law Brent, who is going to be entitled to a piece of that annuity litigation at some point, I've told him that he's not going to be able to buy his sports car with that money when he gets it. He should be able to get something of some value, but there are now 50 to 60,000 treaty people, as descendants of the original treaty people. So, it's going to be divided amongst a lot of people. So it's not going to be a real chunk of change, but it should have some value. So we'll see what that comes to. These treaties also established hunting and fishing rights on unoccupied Crown land, which means lands that wasn't reserved, or lands that the Crown didn't sell to some other entity for whatever purposes. Schools and teachers on reserves were put in place. Again, this was the intent before residential schools were put into existence, and they were paid by the federal government, paid poorly, by the way, and there were one-time benefits such as the getting of animals and guns and clothing and alcohol. Modern treaties after 1975 include the following: basically consultation and participation agreements, which means that the treaties were more holistic to a great degree. It now includes the ownership of lands. Okay, so that's an incredibly important difference between those and historic treaties. So the bands, the First Nations entering into these treaties actually get ownership, not just the usufructuary possessory right, but ownership. They have wildlife harvesting rights, financial settlements, lots of money, as it turns out, billions of dollars sometimes, basically. They get the right of self-governance, incredibly important. That's a Section 35 constitutional right. And so self-governance, is something that is almost always now on the table when a comprehensive land agreement is being negotiated. We'll be dealing with that in next class. That's the topic. There'll also be resource sharing, and those are a function of benefit agreements. And we'll talk about those as well. All right. Specific land claims deal with alleged treaty breaches again, as we've talked about. So the Canadian government as a whole, and has for quite some time, sees the settling of these claims as a recognition of Indigenous rights and respect and reconciliation. So the government, does not want to be in court over the violation of treaties. They just don't. So what they've done is they've set up a system to address claims made by First Nations, and they deal fundamentally with the administration of land. All right, that's almost always what violations of treaties deal with, because obviously land rights are so important. These claims are separate and apart from comprehensive land claims, which are modern treaties. Again, that's next week's class. The process is voluntary for First Nations, basically, so it's voluntary to enter into this. So First Nations have the right. It's not extinguished. They have the right to go to court if they do not want to participate in the specific claims tribunal process, and we'll talk about what that is. As of March of 2018, Canada and First Nations across the country had settled more than 460 specific claims, and there are still hundreds that remain unsettled. Right? There are very few treaties in existence, in this country that haven't at some point been the subject of a specific claim. The process itself is this. So the First Nation submits its claim to the federal government. The federal government reviews the claim. They have 6 months to do so. And then if the claim meets the minimum standard for what they see is a relevant claim, then it will go forward, right? If the claim doesn't meet that standard, then the First Nation can resubmit it and the process is restarted, right? And the standard is that the federal government looks at the claim and says, yes, this does deal with a violation of the provisions of the treaties, right? So that's the standard. So if the claim meets that standard, it's filed with the Ministry of Indigenous and Northern Affairs, and it moves to what's called the assessment phase. So the assessment is an evaluation of the parties' rights during the treaty. And that phase can take up to 3 years. So this isn't by any stretch of the imagination a quick system. During that time, the federal government determines whether to accept the claim for negotiation, whatever particular provisions of the treaty are being put forward. And to be accepted, a claim must demonstrate on what's called a balance of probabilities. So that's the civil law standard of proof. The criminal law standard is beyond a reasonable doubt, right? That's what the Crown has to prove to find somebody guilty of a crime. In a civil proceeding, a party has to prove on the balance of probabilities, which means that something is more than likely, true rather than not true, that Canada has an outstanding lawful obligation to the First Nation. If the claim is not accepted for negotiation, as in the federal government turns it down after that assessment phase is gone, then the First Nation has the opportunity to submit fresh evidence, right, as a function of trying to settle the matter, or it actually goes to the specific claims tribunal, right? If the claim is accepted for negotiation, then it's negotiated. The negotiation process begins, all right? So that process is apart from the tribunal process. If after another 3 years, so this is after the 6 months of the initial looking at it, after the 3 years of the assessment of the provisions of the treaty, after that's taken place, and after another 3 years goes by and a negotiated settlement is not reached, that's between the two parties, either with a mediator or not, but a negotiation does not result in a settlement, then more fresh evidence can be submitted and the negotiation continues, or again, it can go to the specific claims tribunal. The tribunal was put into place, the provision of it, in 2008, so it's only been around 12 or 13 years, so it's not that long ago, right? It created what was considered to be a new independent body, which means it doesn't have somebody who works for the federal government or an Indigenous First Nation, for that matter, sitting on the tribunal body, but the body is created with the power to make binding decisions on the validity of specific claims and can award compensation up to, and this is an upper limit, $150 million per claim, right? There are 4 scenarios in which a First Nation can choose to file a claim. 1, if the claim has not been accepted for negotiation by Canada, right? So we're going back through the phases. 2, if Canada fails to advise the First Nation within 3 years of filing that it will be accepted for negotiation. 3, at any stage if both parties agree. Or 4, if after 3 years of negotiation, there is no final settlement. So those are the scenarios in which the matter can go to a specific claims tribunal. So while they were created in 2008, tribunal became operational in 2011. There is, in fact, a specific claims tribunal that sits in Sault Ste. Marie, just so you know that deals specifically with the Robinson-Huron Treaty. So that case I was just talking to you about with the valuation of annuities, that's before a specific claims tribunal, right? And now moving on to a different phase because it's going to be worth more than 150 million. That's just the obvious conclusion of where it's going. The tribunal sets its own rules of practice and procedure, so it's similar to civil courts. They're overseen by superior court judges. So in fact, we have an Indigenous woman who is sitting on the specific claims tribunal in Sault Ste. Marie. She was sitting in the Superior Court of Ontario in Toronto, in the Judicial District of York, but now has come up to the District of Algoma. All right. The decisions are independent of the government and can only involve the making of a compensatory award, which means the tribunal only has the authority to award damages, essentially. It can't make declarations, it can't make announcements of any kind or issue injunctions, those kind of things that most courts can do. It can only award compensation, right? Canada actually provides funding to First Nations to participate in this process. So again, that's part of Canada's obligation at reconciliation. So the federal government will provide funding for research and development of specific claims, to support First Nations participation in negotiations, and to provide funds for the legal work of those appearing on behalf of First Nations before the specific claims tribunal.